Well, here we are, Mike O'Brien, justice served, and from the heavens, I am coming to you apparently.
Yeah, you are.
For our weekly.
Thank you.
Did you start that?
And, don't look now. But there's somebody next to you. I don't know.
A weekly question. Well, actually, in my view, she's next to you.
Oh, that's
you may
interesting.
notice
Yeah.
that we have a special guest, Sarena Townsend, a great trial attorney in New York City. She's also married, has a husband attorney, but we're not going to promote his name tonight.
No,
we're just promoting her. She is also a guiding host on the Law and Crime Network. Matter of fact, I saw you this morning, Sarena, and was pushing you out of the chair, and tonight I'll push you into the chair. But anyhow, it's our weekly question and answer. I'm going to turn it over to Michael. Michael's been collecting questions from our viewers.
Yep.
We have a lot of questions on apparently one particular case only.
It's funny. Before we get to that, though, let me ask you both, because you were young thugging today, right?
Right.
And, and even beyond that, because I admit I was playing hooky. I wasn't, I was playing golf. Sorry. And tell us, was there a verdict in that? What happened? What happened?
I was on the air when the verdict came in, but I didn't announce the verdict. He was found guilty. They were heading to the penalty phase.
So finally, of the top charge
okay. After 11 hours, and of the abuse of the elder, who was 60. I was kind of like, that's really
embarrassing. To put a number on it like that, I mean, that's just a slap in the face.
Legally old.
So he's guilty, and now they're doing the sentencing phase, which is interesting in Nevada, that for a non-capital crime, for a non-death sentence case, that they go into a sentencing phase and let the jury recommend a period of time up to life without parole. Correct?
Yeah. No, it's very, very interesting. And thugging it, and Sarena was there for most of Young Thug. I kind of like ended Young Thug. Brian Steele had finished his questioning, and then apparently the assassin for the defense whole team took over. That's Mr. Short. Oh. And he ended on like a high note. Like he wasn't even, he was asking questions that Woody, I'm told it's pronounced Little Woody, not Woody.
Yeah, Little Woody. Yeah, I mean, I'm sorry. Your name is
could not answer, and there was an objection from the state, non-responsive, not answer the question. Well, and the judge said, unlike Judge Glanville, said, well, if Mr. Sharp doesn't want to answer this question, that's his prerogative. Let's keep going, and it was kind of like a dagger. The good cop, bad cop, the assassin, and there you go. So that's what happened. But you saw most of it, Sarena.
Little Woody Copeland, he's done now. He's off. He's done. He's off the stand.
He's done now, right? Finally, my God. Yeah. This is the star witness, and he's been on that stand for a while. I mean, the jury's there, the jury's not there. We got ex parte conversations. It's been a whirlwind.
Here's a new wrinkle. I just read about this today. There's an election in November for the DA of Fulton County. Oof. And there is some serious competition for Fonnie Willis. And this DA candidate said, if I win, that case is done. It's over.
Wow.
So yet another wrinkle in that case.
They might have a lot of voters.
Oh, my gosh. That could be a very good platform. Just on nothing else. Put me in. This case is over. I'm saving you a ton of money, taxpayers.
Yeah.
So we'll see. I'm sorry, I can't remember her name. Cortland. Anyway, the Fulton County race, which will be coming up in November. Okay, so on more important things, Karen Reed, we can't get away from this case. And now there's a civil wrinkle, which we knew was coming. I mean, we knew, no surprise, there's a wrongful death matter. So now, just some of the background. Obviously, Karen Reed, charged in the death of John O'Keefe, the Boston cop, boyfriend. Did she hit him with her car? Did he otherwise stumble into a snowbank and die from exposure? She was found. Well, there was a hung jury. Following that, there were a number of jurors allegedly who have come forward saying, hey, we had a unanimous agreement on not guilty counts 1 and 3. Defense made a motion to enforce, in effect, those decisions, even though a little less than formal. The judge denied that motion. It is now going to go up to appeal. And as we're waiting for that to unfold, remember there's a new trial scheduled for January of next year because they have only 1 year to bring a second trial. Now we have the civil case. Wrongful death case. I got it here somewhere. Hold on. The wrongful death matter, right? 22 pages of fun. And this is basically a case brought by a number of folks against Karen Reed and against the two bars that were involved in her socializing that night, the McCarthy bar and the what's the other one? Waterfall bar. Bars that are, amazingly friendly to people that may or may not have been overserved. Here's a drink. You leave one bar with a drink, go into the other bar with that drink. It's a great system they have there. So, wrongful death, emotional distress claims, all against Karen Reed and the bars on behalf of the different plaintiffs, which include the mother and father of John O'Keefe and one of the children. If you recall, John O'Keefe was taking care of his niece and nephew, as I recall, and they were there in the overnight hours when Karen Reed couldn't find John O'Keefe. And remember, there was a phone call that morning. Where is he? Did I hit him with my car? One of the allegations suggests that there's emotional distress because this young child, she's a minor, 14 years old, she was exposed to that conversation on the phone and effectively told that her dad was dead and Karen Reed did it, and therefore the conversation about it caused her emotional distress. That's in a nutshell. So we have this wrongful death case. A lot of folks have questions about it. So let's start right with that. Although these are all peripheral, some of these questions talk about the criminal case, some talk about the civil case, some just talk about Karen Reed. Here's the first one. This comes from Bunk from W.B. Moore. Okay? I'm curious, as a strikingly beautiful woman, do you think the base of support for Karen Reed would be as great if she were less attractive, or a less attractive male, or a person of color? Okay, so, and I guess you can apply that to both the civil and the criminal cases. Discuss.
I'm at a loss of words. I'm sending that to you, Sarena.
Okay, I'll be very honest with you. I don't think anybody could ignore looks and personality and vibes and all of that on any level. The three of us are trial attorneys, and we have to be honest when we say, when we present things to a jury, when we present things to the public, when we present things to anybody, and it's our job to essentially get people to agree with us. Sometimes it involves some, manipulation on some level, right? And so I think the way you present to the public and the way you present to the people that you're trying to get on your side is very important. She's obviously not a lawyer, but she's sitting there. People are looking at her. I don't think we could ignore the fact that looks matter in every context of society. I also do think bringing up the fact that she's not a person of color is important too. Everybody has biases, and it's really unfortunate, but it still exists in today's day and age. There is racism. There's this we cannot ignore. And so I think the question, although we can laugh about it for sure, because yes, she is attractive, and how much does that play a role? But in actuality, this is a trial, and a trial is a performance. It's a show. And, we can't ignore that. We cannot ignore that.
And there will some that'll say, and jury consultants, that you don't want women sometimes judging women, which in this day and age is hard. Yep. We should be supporting each other, but that's some of the trial research that you get from your jury consultants when you go to try a case, depending on who your client is. So,
absolutely,
there it is.
There's no doubt. And now I don't know that Proctor, the Proctor factor, I don't know if he would agree with her being called strikingly beautiful. That was probably not
right. We assumed that, right? We just assumed that was true.
He's had a lesser opinion of her looks, but there's no doubt that attractive people also make cases more interesting. I'm sorry, they do. Those that follow cases have, they feel like the beautiful people. We talk about the Depp Heard case, any of those. They just attract more attention. There's just no doubt about it. Whether it, yes. I don't know that it ultimately helps you with a jury, but it definitely helps the story in terms of telling
like Linda
and the
was
entertainment.
Saying, women judge women, very aggressively, and your level of attraction is not necessarily going to change that. So yeah,
it doesn't hurt to be good looking. I think that's the
well,
ultimate.
Can I just add one thing to that? It is interesting because sometimes I have to have conversations with my civil clients that. When somebody sees you, whether it's a news media reporter or whatever, they're going to judge you within 3 seconds. It's like the book Blink right? They make an initial reaction. And part of that is whether you're exhibiting a power suit. And there's been a lot of talk about power suits recently because of Kamala Harris wearing the Chloe clothes that are custom fit for her, and exuding that kind of power with the dark clothes and the dark suits that match. So it's a discussion that we are uncomfortable. We say, "Oh, you paper, paper. You talked about women or men and what they were wearing," but to ignore it is to ignore what's really happening out there in 98% of the world, and we just tend to think sometimes we're above it.
Yeah, I agree. I mean, it's a superficial society. I'm sorry, it is. Whether we're talking about TV or the performance that is a trial, looks matter, and what you wear matters. Okay, I'm going to skip some of the questions that had to do with more the criminal. We'll get back to them if we have time. I'm going to get into the civil case. This comes from Ambush Saber. Why wait until after the first trial? The act of over-serving, and again, now they're talking about the bars being sued, the act of over-serving has nothing to do with whether or not the person was punished for the crime they later committed. By waiting until the first trial was over, it definitely comes across less about actual justice. So I think there's a number of different questions in that mix. But let's break it down here. Linda, why wait till after the first trial?
Well, some states, and I don't know if Massachusetts is one of them, has a doctrine that you have to bring all your claims in one suit or the bar. New Jersey has been that way for 30 years, and hence the federal courts that police New Jersey, and the same with some other states. So that's one thing. Secondly, if you're going to tell the whole story and you're going to get all the insurance policies in, because that's what this is going to be settled on. It's not going to be settled on who's right and who's wrong. It's going to be settled on how much money is going to go on here. You want that basket of insurance policies. You want them all in. And the third thing is you did want to see whether she was going to be judged liable, because it may help the case, it may hurt the case. So you want the results of that first verdict at least to come in, as long as it doesn't interfere with what is called the statute of limitations, and that's the statute of which you can bring claims. And that varies in different states. In some states, survivor claims only 1 year. In other states, it's 2 years. In some states, a wrongful death claim is 2 years. In some states, it's 3 years. So you have to be aware, if you're a civil attorney, to bring all that technical stuff that I know the viewers don't care about, but the civil attorneys, they do.
Yeah, and it makes sense. It's 3 years in Massachusetts, which would mean January of this coming year, so of 2025. So they have time, Sarena. It's not like they're pushing the clock. So what other motivation might they have for bringing the action now?
Well, sure. I mean, look, if she had been found guilty, right, then
it's a slam dunk. You got it made.
Yeah. The burden of proof in a criminal case is beyond a reasonable doubt. So if you've been able to clear that hurdle, and they obviously were hoping that they did, then they could use the proof of that conviction in the civil case, because the civil case, preponderance of the evidence, that burden that they need to meet is way lower. So strategically, it makes a lot of sense to try to wait that out. So I could understand the delay there.
Yeah, so I mean, obviously in a criminal matter, if you have a conviction, you just take that, you walk it across the hallway to your civil case, and then you just start tabulating money. The other thing about the civil case, obviously, is, does anybody think that Karen Reed has a lot of money stored up to pay off on a judgment? No, it's all about the insurance for the bars. So that becomes a real interesting question, and I may have to ask that question myself. I'm not sure it was asked by one of our viewers, but the dram shop type issues, the liability for a bar for over-serving, it's different in every state. Some are very liberal about it. Some are very rigid. What do you think? I'll give you each bar. Let me start with Linda. Let's start with the McCarthy bar, which is the first bar. How do you judge their liability in this case?
Michael, to be true, I don't know. Okay. Obviously, they all left to go to the waterfall, right? Was there something said at that bar that said, "Hey, no more serving"? So I don't know if we know the whole story on that first bar. I have to tell you.
We know in McCarthy she had. I'd find this hard to believe, but this is according to the complaint, and I think it's important to point out, as you guys know, in federal court, complaints are verified, which means you are stating allegations, based on what you believe to be true under penalty of perjury. But in most civil cases, it's on information and belief, which means you can kind of hang it out there. So if they're saying, and let me reference the complaint here specifically, because I noted some of the numbers here. They say at paragraph 18, at McCarthy's, that she had 7 drinks between 8:58 and 10:29. That's an hour and a half for 7 drinks. I'm on the floor. I'm not getting out of any bar after
Michael,
7
you're
drinks.
Lightweight.
Apparently, I am.
And you don't know, and we don't know if that really happened. And we don't
don't
know
know.
somewhere
Again,
somewhere's
that's
in
my
between
point.
that. Right.
On
Somewhere's in
information
between,
and
somebody
belief.
said, they weren't going to serve her. Maybe she was buying drinks with somebody else, so they have her actually drinking them on the camera. I wasn't clear from that first trial exactly how that came down, and that's going to be something that obviously in the civil case, the attorneys are going to have to, as they said, suss out.
Yeah, they're going to suss that out. So Sarena, now she goes to the Waterfall bar. You're the Waterfall bar now. You represent them. She goes there and gets 2 more drinks.
Yep.
Okay, so that's 9 between, let me get the 8:58 p.m. and 12:10. Okay.
Yeah. So here's the thing there. It goes both ways, right? So like if she's exhibiting severe signs of intoxication, you're going to start saying to the Waterfall bar, you're liable because you saw the condition she was in. She came in, she's swaying, she's slurring, she's bloodshot eyes, she stinks, she's got a drink already. And now you're continuing to serve her. That's a problem. On the other hand, though, you have this kind of limitation of the 2 drinks, right? So like if she's not showing those external signs, if I'm the Waterfall bar, I'm like, I only gave this chick 2 drinks in an hour. They gave her 7. Like, they're the ones who are liable here. How am I supposed to know it's a busy bar, this and that? So there's definitely ways to argue it on both sides. And I think when we suss it out, we're going to see a little bit more of...
And if you don't know what Sarena are talking about, it was the trooper was it a trooper or what was it? A police officer that was thinking about having a relationship with her. And he was confronted with all these texts, and he said he was just trying to suss it out what her intentions were in case
well, it was
sus.
Yeah.
It was sussed.
As my daughter likes to say.
I think we know in reality what will happen. Again, there will be a rigorous defense up front. Probably summary judgment motions. Who knows on the civil level, and then the insurance companies are going to get together and they're going to figure out who's paying how much. It's just very convoluted when you have, again, if you believe these allegations, 7 drinks from one bar followed by 2 from another. So at some point, if those numbers are legit, unless she has the tolerance for alcohol of an elephant, at some point she's going to exhibit signs that suggest, maybe you should cut her off. I don't know that a jury's ever going to have to figure that out. I think it's going to be handled with insurance adjusters and maybe some depositions, and that's the end of it.
And then what we haven't talked about is she get to take the 5th Amendment.
Oh, yeah, and that's Michael. A good tease. I got a question in here somewhere from somebody. Let me attribute that to somebody before we get into that. Stand by.
I'm submitting my question to Justice Served. And by the way, subscribe to us on our YouTube channel if you're watching this.
Yes, please do that. Let's see. I know I have it here somewhere. Oh, it's out of order. This whole court's out of order.
The whole court. He does that purposely so he can cite Al Pacino.
Yes. I could use that the other day again because I'm telling you, back to the Young Thug matter, that case is out of order. 2 or 3 people were asking similar questions, so maybe I'll just kind of synthesize that into your question, which was, can she take the 5th in a civil matter? And if I find it, I'll attribute it to the right person here. That's the question. If this were to go to a civil deposition, which is more likely than anything else between now and the criminal trial, can she take the 5th?
Linda, take it away.
We're jumping.
Ask the question and answer it. Yeah.
Okay, so if she were bringing this action, right, the answer is no, unless she would waive the action. It depends. Okay, this is going to be like an it depends answer. Technically, she really can't bring it because the judge can order her to answer these questions because she has a 5th Amendment right if she wants in a criminal case. But some states are very loose with this. Okay, now the federal court would make her answer the questions, holding that she would have no 5th Amendment right. But the state courts, they're kind of loose and willy. They say, okay, wait a second, this is not a criminal matter. She has to answer the questions. Other courts will do this, and this is the practical thing that usually happens. There's a motion by the defense to stay her deposition pending the outcome of the criminal case. Right. The judge doesn't want to put anybody in a position where the judge is wrong and cause somebody to waive their Fifth Amendment rights, and they will stay her deposition testimony and answers to her interrogatories. That's what usually happens, but that's not what has to happen.
A great answer, Linda.
Yeah, Sarena, what do you think? I mean, because I have seen cases in which, pending the criminal matter, they have, gone through some discovery up through and including depositions. If that happens, and she still has the potential for criminal charges, as she does now at this moment, she could take the Fifth in a civil deposition. She's going to sit there and take the Fifth, right?
I'd want to if I were her. I don't want those statements coming back to me at all. Keep in mind also, by the way, even the very fact that we know she was drinking, there's surveillance, there's the receipts, and then getting into a car. I mean, even just that's a DWI. She loses credibility, and it's problematic, even if they don't come to the ultimate conclusion about the death of O'Keefe. So there's a lot of layers here to think about with respect to her liability, both criminally and civilly.
Right, and think about the Alec Baldwin case. He didn't have to sit for a deposition in New Mexico. But I will tell you, there's a difference of opinion. For our viewers who really want to be lawyers, because I know you all really do, all right? In federal courts, if you are asked your name in a deposition and you're taking the Fifth, you can't answer that. That is considered a waiver of your Fifth Amendment rights. In state courts, they'll say, answer that question, or they'll parse out something. Where do you live? The blah, blah, blah. And they'll parse out something they believe. But in federal court, there's case law and this all over. And trust me, when you're a young lawyer and you get yourself into trouble, then all of a sudden your client is like possibly waived your Fifth Amendment, you never forget that.
Yeah, that's brutal. That's brutal.
Live and learn.
Here, it's this person has written us questions before. No_campaign 8416, and it was, can they force a deposition of Karen before the retrial? And if they can, is she allowed to plead the Fifth since the retrial hasn't happened yet? I think we've covered that.
It's a great question.
So yeah, it is. And that's why it's probably useless to do that prior to the criminal matter. But it still makes me wonder, what's the underlying reason for filing that action now? What are they trying to do? Are they really just trying to force a settlement with the bars just to get the money? Does the O'Keefe family need the money? Is that the true motivation? I don't know.
Maybe they're just getting antsy.
Yeah. Obviously, we know it would have been far better for them had there been a true guilty verdict at the time of the
Well, would it have been?
trial.
I guess it would have been for the issue of the bars, but then could the bar have argued that there was an intervening? Well, no, because they have served her. But so I guess they can't argue intervening act of some sort, can they? Or could they? Could they argue that this was a criminal act and therefore the policies only applied to the service, but this was a criminal act because she had revenge out to get him and she wanted to kill him? Because remember, the charge was murder.
Right.
So you're suggesting that her actions are some superseding act that would cut off the bar's liability?
I think they'll argue that. They're not going to get. That's not going to get it, but they're going to try to argue that. I think to try to reduce their bucket.
Okay, so here's a question from real Mike Dexter. What couldn't they get from them in the criminal trial that they might get from them in a civil trial? He says, obviously, the truth. But other than that, So what, Sarena? What's the benefit of a civil trial? Is there anything they can learn? Talk about maybe some of the experts. I don't know.
I mean, I don't know either. For sure, there could be more expertise that comes out. Didn't they have? Wasn't there a bar on some information coming out from the FBI's examination or investigation into the cause of death? There had been a separate investigation, I thought, that was done and came up with the fact that the car could not have been the vehicle that caused him to fall and ultimately die. And I think that there was some sort of ruling in the criminal case that didn't allow a lot of that information out. So I do wonder if there's some information that'll be let out in a civil case, in a civil trial, that was otherwise not allowed in the criminal case.
That's a good question. And one of them, again, that I have here somewhere at my fingertips, their question was, can the bars use those FBI experts who were deciding the case for the defense that there was no collision between Carr and O'Keefe? Can the bars use that as information to protect them, Linda?
Yes, they can. They can subpoena those witnesses because for the bar, they are fact witnesses. They're not an expert opinion. This is what they testified as fact. They've reviewed reports, or they can rehire them and say, "There's your intervening cause. It wasn't that we served her alcohol. She never drove a car into him, and therefore we are not liable." So there you go with an intervening cause.
Yeah, those guys are golden. That FBI stuff.
Guys and
Okay,
girls, it's a generic thing.
what's that? What's that?
Guys and gals,
Guys
Oh,
guys
and
and
sorry.
girls. They
Yeah,
are.
dudes and
It's a
dudettes.
constant. It's a
Yeah.
constant thing.
Okay, I had another question here about. This is kind of an interesting question because there are some emotional distress claims in the civil case, which are really interesting the way they're structured. I do think, in general, they've done a pretty good job of pleading. Pleading is an art. That is the drafting of the complaint. I think they've done a pretty good job. They've identified the parties clearly, the allegations they believe lead to the causes of action. I think all that's great. Sometimes there's pleading can be a mess, and then subject to either a demurrer or some sort of motion to fix it. I think it did a pretty good job. But as to these emotional distress claims, this person, Coroner Gas Brent, says, I'm unsure of the legal term, but wouldn't anyone be barred from suing for emotional distress based on court filings and testimony? So they're suggesting that, I don't know if there's referencing sort of a litigation privilege about the things said during a court proceeding that can't be the basis for defamation. That's what it sounds like to me, but that's different, Linda, than an emotional distress claim.
Right. One of the statutes, I believe it's the wrongful death statute, specifically allows for emotional distress as a damage. For instance, his father is killed by an auto accident. A young girl sues, for instance. You have survivor actions, which really go to it can go to the pain and suffering, between the time of an action which calls a death, and then you have the wrongful death, which can go to emotional distress. I think I have that right, Sarena? You go to
Yeah,
emotional distress and
that's right.
different damages. So they have two separate statutes are referenced in that complaint. They have two different sets of damages in that complaint. So that's the phone. That's why the phone call outside, which the young girl, the niece, hears, and then she hears, and she is completely upset over it because of the actions that she says were caused by Karen Reed.
Yeah, give me your thoughts on that, Sarena. Specifically, Kaylee Furbush is the minor. She hears, again, these are all allegations. She hears Karen Reed on the phone. I hit him. It's almost matter of fact the way the allegations are laid out. What do you think about that, just on its face, as an emotional distress claim?
It's interesting. I mean, is that like a foreseeable thing that could have happened, that she overheard this conversation? I don't know. In fact, though, I am sure she did suffer emotional distress after hearing that. I think part of it will also be, well, what happened after that? Did she seek therapy? Did she seek help? How are we going to prove? I mean, aside from the fact that obviously this is so distressing, the worst obviously distress that you could have is finding out that your parent has passed away. But how much distress is going to have to be measured. I also think Linda brought up a really interesting point about the pain and suffering, because it's true. The impact and then the eventual death. I think it'll be interesting to find out through maybe medical records or some experts. Do we know how long he was suffering before he died? Right? Because sometimes an impact could have caused the death right away, but it looks like here it didn't, and he was suffering, and who knows how long he was suffering in that bank of snow before he passed. And so I think that's going to add to the damages potentially, also the pain and suffering part.
And as to the kid, already, and they certainly noted this in the allegations, John O'Keefe took this niece in because her parents had already died. So it's compounding whatever stress or emotional injury there may have been, because now here's this person who's taken her in to care for her because her parents had died, and now he's died, allegedly, at Karen Reed's hand.
And he's like the de facto parent at that point.
Yes, and I think it's a little unclear, but I think the mother of John Reed, John O'Keefe, is actually the official guardian, but he was truly taking care of the kids. So that's why they have the claim, and that's why the connection to him is so important.
And Michael, our fun time is almost over.
I know. I just noticed that. Okay, then. all these other questions I have. I'm sorry.
Oh no!
Sorry,
he's kidding you. He's saving them for next week. He's saving them for next week.
Yeah, because nobody wants to stop talking about Karen Reed. So obviously we'll keep track of all of that. Here, let me try and play us off with something. Hold on, let's see if I can make this work. Here, stand by.
Well, I was dancing to the intro. Let's see how yeah.
There it is. Okay, guys. We'll see you next time. Take care.
Thank you for having me.